Good afternoon and welcome. It's after 12, so we're going to get started with our Lunch and Learn presentation this afternoon. I'm Karen Visser, and I'm the chair of the Bench and Bar Committee of the Bankruptcy Court of the Northern District of Georgia. This is the presentation of the 13th installment of our Lunch and Learn seminar series. I'd like to extend a huge thank you to our IT team for getting us set up on Zoom today and recording our panel who are here in person today. They'll also be assisting us by making the materials and a recording of the presentation available on our website. Just go to ganb.uscourts.gov and click on the Bench and Bar tab to find it, as well as our past programs. Go ahead and please put your questions in the chat as we go. And if we have time at the end, we'll try to get to as many of those questions as we can. Today, we have with us Judge Sage Sigler, Vivian Jones, and Lauren Drayton. Judge Sigler was appointed as a bankruptcy judge for the Northern District of Georgia in 2018. She succeeded the Honorable Mary Grace Steele, for whom she clerked after graduating from law school. She earned her JD from the Emory University School of Law, where she was executive symposium editor of the Emory Bankruptcy Development Journal, and earned her BA in political science from the University of Florida. Prior to her appointment to the bench, Judge Sigler was a partner in Alston and Bird LLP's bankruptcy group. Vivian Kelly Jones joined public service in 2009 as a trial attorney for the U.S. Trustee Program in the Northern District of Georgia, before transitioning to the Office of General Counsel for the U.S. Trustee Program in Washington, D.C. She currently serves as an assistant U.S. attorney for the Northern District of Georgia. Prior to her tenure with the Department of Justice, Vivian worked as an associate in private practice, where she focused her practice in the areas of bankruptcy reorganizations and complex litigation. Vivian earned her law degree from William and Mary Law School and her BA from the College of William and Mary. She also served as a law clerk for Judge E. Stephen Derby of the Bankruptcy Court for the District of Maryland. And we have Lauren A. Drayton, who's currently a managing attorney for the Semrad Law Firm, LLC. She joined Semrad as an associate attorney in 2012 and was the managing attorney for the Chapter 7 department from 2016 to 2024. Prior to her bankruptcy practice, she worked in trusts and estates and civil litigation. Lauren earned her law degree from the University of Georgia School of Law and her BA from Emory University. We are delighted to have the three of you with us today to be discussing the treatment of student loan debt and bankruptcy.
All right, thank you so much for joining us. I think I'm going to kick us off, right? And I will give everyone a little bit of background on the history of student loans and bankruptcy, how we've ended up where we are and where we think we might be going. So student loans were fully dischargeable in bankruptcy prior to 1976. No limitations. You filed for bankruptcy, student loans were one of the debts, and it could be discharged. In 1976, the Higher Education Act made it such that student loans were not dischargeable within the first 5 years of repayment unless there was an undue hardship. So we've had this undue hardship concept since 1976, but it was only if you filed for bankruptcy essentially within 5 years after graduating, finishing school or entering the repayment period that you would have to prove undue hardship. If the loans were older than that, they could be easily discharged. 1978 is when that got codified into 523A8, where it still is today, and clarified that it related to loans backed by a governmental unit or nonprofit educational institution. Now it's any loan backed by a nonprofit institution is non-dischargeable as of 1984. There are some other, 1985, they changed the statute of limitations on collection of defaulted student loans to 6 years. So that gave struggling borrowers a different kind of out. 1990, under the bankruptcy code, the time limitation for discharging student loans extended to 7 years. So if the loans were less than 7 years old, you had to prove undue hardship. More than 7 years old, they could be discharged. And then it was not until 1998 that the ability to discharge student loans after 7 years was eliminated, and that you had to establish undue hardship in all instances. And the reason that I'm walking through all of this is because, and perhaps, I should give the disclaimer, don't cite me to me. That's Judge Bonnefeld's line. I think I saw him on here somewhere. But in my mind, all of the case law that we rely on for what do you have to do to prove an undue hardship, and I'll walk through some of that, but that was all decided under a regime where student loans were dischargeable with no additional burden. You didn't have to prove undue hardship as long as they were more than 5 years old. Before I get to the case law, just briefly, there have been some legislative initiatives over the years to change or clarify 523A8. And those efforts have been bipartisan for the most part, but they really haven't gone anywhere at this point. There could be some more recent ones, but at least as recently as 2019, there was an effort to drop the undue hardship requirement altogether, but that didn't go anywhere. So the case law that we currently have to deal with, you have to, under 523A8, if you want to discharge student loans, no matter their age, you have to establish undue hardship, and we rely on what we call the Bruner test to do that. Again, the Bruner test comes out of a 1987 case out of the Second Circuit. So again, 1987, you could discharge your loans after 5 years. So the debtor, Bruner, had graduated very recently and then filed for bankruptcy and sought to discharge her student loans, and so was within that 5-year period. The Bruner test has been adopted by the 11th Circuit, so that is the law that we travel under here in the 11th Circuit. And the Bruner factors are essentially that you cannot maintain a minimal standard of living if you're forced to repay your student loans, that your circumstances are likely to persist, and that you have made a good faith effort to repay your loans. Now, again, the bankruptcy code does not say any of those things. 523A8 just says that you cannot discharge student loans unless accepting such debt from discharge would impose an undue hardship on the debtor and the debtor's dependents. It doesn't tell us what an undue hardship is. But those Bruner factors have essentially become the test for determining whether an undue hardship exists. Now, there are courts over the years that have read sort of harsher requirements into Bruner, despite there no longer being a time limitation on how old the student loans are. And so perhaps you've heard the phrase certainty of hopelessness, that a debtor would have to establish that there is a certainty of hopelessness regarding their financial condition, and not simply a present inability to repay the loans. Certainty of hopelessness is a pretty harsh standard. And I will say, as a judge, having written some opinions in student loan cases, knowing that the debtor is going to read it, it's hard to tell someone, I have heard all of your testimony and you are certainly hopeless. It's a really stringent standard. And again, that language does not come from the bankruptcy code. So in that vein, some other courts have attempted to narrow or clarify Bruner and basically saying, look, Bruner says what it says, but 523A8 says what it says. And so in the bankruptcy court for the Southern District of New York in 2020, it was Judge Cecilia Morris, who is now retired, which ties into all this. So the case was Rosenberg versus New York State Higher Education Services Court. And I'm oversimplifying this, but essentially Judge Morris said she granted summary judgment to the debtor, and said, 523A8 says undue hardship. This debtor would have an undue hardship if he has to repay his student loans. And she really ignored the Bruner factors and said, there's nothing in the bankruptcy code that requires me to walk through that. Not surprisingly, ECMC, these were not loans held by the Department of Education, which we'll get to the significance of that in a moment. This was litigated by ECMC, and they appealed. The district court reversed and remanded and told the bankruptcy court she was required under the Second Circuit law to walk through the Bruner factors. And even though that was in 2020 or close thereto, the case is still being litigated. There were some additional appeals that went up regarding the debtor's proposed expert, or no, ECMC's proposed expert witness. That appeal was ultimately withdrawn. That was in the 2022 timeframe. And then I just checked on it again this morning. And it looks like we're still waiting for the remanded trial to happen in the bankruptcy court because Judge Morris has retired. There's a new bankruptcy judge. And so looks like they've had a couple of pretrial conferences, but we're still waiting to see what happens there. As I mentioned, I have issued a couple of opinions in student loan hardship discharge cases. Both of those were litigated against ECMC. So again, they were loans not held by the Department of Education. So they would not be subject to the DOJ guidance that we're going to talk about. But it all still ties in because the factors that the DOJ guidance considers are essentially the same as what you would have to establish in court under the Bruner test. So the first case to look at is Hill versus ECMC. It's 598 BR 907. That was a 2019 case. And I think the significant thing to note, and again, I mean, of course, other judges in this district are not bound by my decisions, even if some of the portions of my decisions were adopted by the district court in other bankruptcy case, or sorry, in other cases, that's still not binding on our judges, but at least I have held that factor one, which is whether you can maintain a minimal standard of living if forced to repay. I have held that factor one is based on the actual required payment, not a hypothetical income-based repayment. So oftentimes in this litigation, you know, the actual monthly student loan payment would be $1,100 a month. But ECMC's argument is, well, the debtor has the option of opting into this income-based repayment plan, and they would have a payment of $0 under the income-based plan. And I said, that's great, but the factor is about if you actually repaid the loans. And that was my view of that was adopted by the district court in Grady versus ECMC, which is 615 BR 336. I also held that factor three, which is the good faith effort to repay, can be satisfied by keeping loans in deferment or forbearance. So this particular debtor in the Hill case had never made a student loan payment. You can read the opinion for why that all still works in terms of good faith, but she had managed to keep the loans in deferment or forbearance the whole time. She had not simply ignored the obligation. And then finally, failure to enroll in an income-based repayment program is not per se bad faith. And again, the district court in Grady adopted that position as well. ECMC did not appeal the Hill decision. So, and then I had Savage versus ECMC, which is, well, there might be a bankruptcy site now, but 2023 Westlaw 2747198. That was March 31st of 2023. And this was a different situation. The debtor in Hill had some very serious mental health conditions that really prevented her. I mean, it was a sad story, really. Very educated woman with a promising future, and then was diagnosed with bipolar, with psychosis, had periods of homelessness, etc. Savage was a very different situation where the debtor had worked for 25 years since graduating from college, but his income had averaged less than $14,000 a year in all of that time. And it was essentially a situation of past performance is an indicator of future success. And there was just nothing about that particular debtor's situation that was going to change. So all of that is just to say, if you do end up having to litigate one of these, there are a number of more recent cases out there that I think are looking at the Bruner factors a little bit more closely in terms of what they really mean and what they really require. But at least for loans held by the Department of Education, I would absolutely commend that you consider the DOJ guidance process. And so why don't you get us started on that?
Absolutely. Thank you, Judge. And I want to say thank you to the Bench and Bar Committee for setting aside the time for this presentation today. And preparing for today's Lunch and Learn, I realized that it has been almost 2 years since the Department of Education and the Department of Justice jointly issued student loan bankruptcy litigation guidance to be used in dischargeability actions involving federal student loans. Today, you'll hear a brief overview of the process for federal student loan discharge cases. You'll also hear some information about the specific form that is used to facilitate that process. But to the extent that after today's presentation, you are interested in any additional information, I would commend you to look at justice.gov. At that location, you will find the guidance documents. You'll find a fillable version of the attestation form that is used within the process, and you'll find additional related details. So please consult justice.gov. Now, I am the Assistant U.S. Attorney that is responsible for student loan dischargeability cases involving federal student loans here in the district. And it is important that I share with you that I'm appearing here today in my individual capacity, and any views that I espouse today, any opinions that I share do not necessarily reflect the views and opinions of the United States Department of Justice, the United States Department of Education, or the United States Attorney for the Northern District of Georgia. Now, in a little bit, you will hear from Lauren Drayton. Now, she filed a significant number of the initial student loan dischargeability cases under the guidance in this district. And so she may have some helpful viewpoints to share. Before I turn the floor over to her, however, for the first tip of the day, I do want to frame our discussion with a few figures. Now, I want to make sure that you're aware that these figures were compiled by me and represent my estimates only. They are not official in any other fashion. And so what you will see here is that since November 2022, I've seen approximately 57 adversary proceedings involving federal student loans, 33 consent judgments, and approximately $3.7 million in discharged debt. Now, with that as context, Lauren, I turn the floor over to you for tip number 1.
Excuse me. Oh, there. Thank you. Oh, there we go. Collecting the information in advance is tip number 1. I think that many firms, including ours, you have a kind of initial consultation with a potential client. You review their general situation, do they qualify for bankruptcy protection? Which chapter might be the best suited? Should they file? When should they file? And now basically I added an additional checklist to that process where when they say that they have student loans, federal or private, I have an additional checklist that I go to that basically mirrors the criteria on the attestation. And in addition to some other questions that get at whether or not, a different avenue may be suitable for their situation. And along with the income and expense questions that you're probably asking about anyway for the means and schedules I and J, at this point you do have some indication of whether or not they likely qualify. At this point you probably haven't or may not have seen any documents. It's just part of the initial information and gathering of just the basics of their situation. I do think that in order to fulfill your professional obligation to your client or potential client, you do need to provide a basic analysis of their student loan discharge situation, prior to filing the main bankruptcy. Many actually will probably not be interested in moving forward, even if they do qualify, but you need to go over the basic analysis to give them the proper advice regarding their options, and also to let them know that it is going to be possible, assuming they still appear to qualify, to open their main bankruptcy at a later date in order to file that student loan adversary. I think cost is unsurprisingly probably the biggest barrier that I have seen for clients who seem to qualify for a student loan adversary under the new guidelines. Usually that is something that they do struggle with, and the hope is that, as either their financial situation improves going forward, or the lack of a student loan payment strategy becomes more of a burden, it might be something that they either have the funds or desire to do at a later date. So I do think it's important to review that with every client or potential client, and then just also to give them the very basic instruction that this is not something that they have to decide when they file their main bankruptcy, or even within the months before the main bankruptcy closes. And there is some reason to either believe or hope that we may be getting an uptick in clients that are interested in filing a student loan adversary. The 1 year grace period following the 3-year pause on student loan repayments during the pandemic has ended now, and a lot of collection options are open again that had not been utilized. And so there may be a reason going forward that some of your clients who just were not very interested have reason to want to pursue this. So if they are interested in pursuing a student loan discharge, you can then move to collecting the documents and information that you need from them to see if they qualify under the guidelines, because that's what we're talking about, but in general as well. So what documents do you actually need? For the present prong of the analysis under the attestation, it's probably pretty much the same documents that you're gathering for schedules I and J and the means test anyway. Basically, I have a little Excel spreadsheet where I make the adjustments, because of course you're adding back in things like Social Security income or VA benefits that you may not need to use under the means test. And I just have a tab where I put in all of their actual expenses, and then have another running column with, the national standards or the local standards. And at the end of that, it's, pretty easy to see whether or not they seem to qualify under the present prong. Do they have money left over? And again, just as a reminder, if they do have money left over, that's not the end of the analysis. They may qualify for a partial discharge of their student loans.
Which, let me just add a point to that. I do not have the authority to grant a partial discharge. That has to be done with the consent of the Department of Education. And I have absolutely seen consent judgments come through where the parties do agree on that. But if you go to trial on one of these things, that under 11th Circuit law, that is not an option that I have.
Yes, thank you. So other expenses that you can include are necessary expenses, and as well as anticipated future expenses. I have heard from some attorneys that they're maybe reluctant to file the student loan adversary under the new guidelines, or intending to use the attestation under the new guidelines in a Chapter 13 because of the concern that the plan payment just kind of automatically turns into excess income, which I don't think that is something that you have to be concerned about. Just as a starting point, the chapter, I've filed my adversaries in the context of being the manager for the Chapter 7 department, but again, I think you can feel comfortable, at least as an initial starting point, with filing them in Chapter 13s as well, and for a couple of different reasons. One, the analysis is completely different in terms of what what determines whether or not there's excess income. What your client has been doing to make a Chapter 13 work is not necessarily what they can be or would be expected to do in the years, following the bankruptcy. And for at least our firm, some of our 13s are high income individuals, but a lot of them are pretty much similarly situated to a Chapter 7 client. They just happen to be behind on a car loan that our Chapter 7 client is current on. And so a lot of the excess income represents a car that's already 5 years old. And by the time they finish the bankruptcy, it's going to be another 5 years older. And so they're probably going to need a new car. And there goes your excess income.
And on that
there.
point, on the Chapter 13s, I will say that we have seen a number of Chapter 13 cases that have moved through the process. Generally, it's helpful if the adversary proceeding is presented when a client is at least 75% of the way through the Chapter 13 plan. At that point, we've got a greater sense of the likelihood that that plan would be completed, and we're not in a position where we're just making a recommendation that may not in fact be supported by the client's performance for the rest of the plan.
Absolutely, and I've heard from attorneys practicing in other districts that some of the judges, and I don't know if you have an opinion, but some of the judges say, don't file this in front of me, or don't bring this to me unless it's like 1 year from when the plan is expected to complete. So it certainly would impact the timing of when you file, but it shouldn't impact, just as a starting point, whether or not you feel like you could file.
I really haven't seen a lot of them in Chapter 13 cases, and that doesn't mean that they don't exist in my courtroom, but just in terms of what makes its way actually in front of me and gets called to my attention. They're mostly Chapter 7s. A lot of them are pro se. I have seen an uptick in the number of consent judgments that are coming across, but in a Chapter 13 context, at least in my courtroom, if the debtor and the Department of Education have gotten to the point where they've reached a consent judgment, I'm probably not going to complain about the timing of that.
So in addition to the documentation you need for the income and expenses, you'll also need to have the client pull their National Student Loan Data System file. And that you are going to have the client pull. This is not something, this is still something that it's a criminal act for anyone other than the client, other than the borrower, to access their own file. And then there's a couple of different ways that they could access it. There's a fairly straightforward, tip for guideline for downloading it as just a simple text file, which then they can send to you to review. They can also, take like more of a screenshot approach to it and send you that. It's a little easier to read that way, but also harder to know if you're getting all the information. So that's why the simple text file is the most helpful. And that will have things like, loan amounts, disbursements, outstanding principal balance, loan status, did they consolidate? Are they in forbearance or deferment? How long did they spend? Payment information. It has really the information that you'll need to determine whether or not they qualify under certain of the future and past prongs of the attestation.
And I'm imagining too that a lot of debtors probably don't necessarily even know or understand, are my loans Department of Education loans? Are they some other kind of federal loan? They might be a private loan. I mean, I don't know how, when debtors are coming to you, how often are they sort of on top of all of that versus how often are their loans are in default and they don't even know what the loans are or what the monthly payment is. They've kind of thrown their hands up in the air.
No, absolutely. I think that the main thing they know is that they have student loans, whether or not they're in deferment or forbearance. Often they know that, but no, they estimate that they've, made certain payments over a certain amount of time. And yeah, it's not something that that they understandably can be reliably expected to convey that information, but the file has all of that. So you can run it through, you can analyze it all yourself, which for the cases that I have done, that is what that is how I've done it. You can also have it uploaded and run through one of the programs that either Stretta or the Student Loan Toolbox. number of other places probably have portals that do a lot of the analysis for you. Again, I haven't used them for the cases that I've worked on so far, but I will say that I've done demonstrations, they've done demonstrations for me recently, and it does seem like a very helpful, thorough analysis that may save you some time and not cost your client very much money to run them through one of those programs for an initial analysis. But whether or not you do decide to use that or review the information yourself, you're definitely going to need to review this criteria to give your client the best advice about their options. Tip 2 is understand your client's student loan hardship narrative, which is critical to preparing the strongest attestation possible. This is actually pretty different from the general petition preparation that you do, where your client's personal experience or their life story is meaningful, but not necessarily particularly relevant to a lot of the information that you need to fill out the petition. This is actually an instance where the narrative is important because you are telling your client's hardship story. So using the questions in the attestation as guideposts, you're going to want to have a conversation with your client about what their experience has been, probably starting with around the time that they were in school and continuing through the subsequent years and decades. And they'll talk about how they had to leave school twice to care for sick parents and they were not able to return the second time, or how they did complete school but then it shut down and they weren't able to use the facilities or the professors in order to train for their boards and didn't pass them. And they'll kind of go through the subsequent years and decades and talk about how that initial setback ended up impacting their job potential, impacting their finances, and really made it difficult to achieve a lasting financial security. And going in through that, they'll also talk about the efforts that they made to increase their income and reduce expenses and manage this debt responsibly. One person told me that she kept on making the $25 monthly payments even when her only income at the time was friends and family contribution. And so really for each of the attestations that I have done, there really is a compelling story behind what happened and why the student loans are a burden and why they should be discharged. Tip 3 is identifying the proper defendants. It's pretty straightforward for the cases that we're talking about here. The proper defendant is the United States Department of Education. That being said, the first few adversaries that I filed, I did include the servicer as a defendant, but that is not correct. And now we still include them in the certificate of service. They do not need to be a defendant to the actual adversary. I haven't done any against private student loan creditors. If I were going to, just as a matter of personal preference, I would file it as a separate adversary just to kind of make everything cleaner. To my knowledge, there are no private student loan creditors who are voluntarily following the attestation guidelines. So I just think it would be a cleaner, simpler process for you. Just to give you an idea of some of at least the timeframes that we're currently looking at, once you file your student loan adversary, it's been taking recently, in my experience, about 2 months to get the packet from the Department of Education back. And then once you submit your attestation, maybe 2 or 3 months to get a decision back, at least just from the ones that I have handled. And I just feel like the private companies, the timetable would be completely different. And you have your main case potentially closed and discharged long before you were able to resolve the private student loan adversary.
I think you're making a good point here. I do believe that where there are both private student loans and federal student loans in the same adversary proceeding, you do end up risking having the 2 different matters proceeding on separate tracks within the same adversary proceeding.
Yeah, I hadn't really thought about that. I mean, if you did file it together, there would be procedural ways we could handle that, staying it into, the only other thing that pops into my mind is whether whether the judge would want to know or whether you would want as part of your complaint against the private student loan creditor that you went through this attestation process and your client received a consensual hardship discharge from the Department of Education. Does that send some sort of message? But you could accomplish that either way, either by doing it all in one proceeding, or I guess in that case, maybe you would file against the DOE, do the attestation process, get your consent judgment, and then file against the private creditor. Oh, present a well-drafted complaint. Yes, so we just talked about some procedural aspects of that. And I think that the keys here, again, I mean, it really goes back to, yes, you are trying to tell the story in this narrative, but make sure you do it in a way that walks through the factual allegations that you need to establish the Bruner elements. So the cannot maintain a minimal standard of living and forced to repay, circumstances are likely to persist, and the good faith effort to repay. I think that sometimes, and again, a lot of the ones that I'm really looking at are drafted by pro se debtors, and so it's understandable that they're not going to understand that they need to focus on these three factors. But you can tell your story in a way that also, you know, really explains to the judge in a very direct manner, you know, here are the factual allegations that relate to the debtor's living expenses, the cost of the loan, and how the debtor, you know, wouldn't be able to pay rent or buy food if they were paying their student loan, circumstances likely to persist, good faith, et cetera. And that's where I think looking at some of those more recent student loan opinions that talk about maybe you don't have to participate in an income-based repayment program. Maybe you don't have to even have made student loan payments to meet that good faith requirement. You know, I think all of those are important in terms of presenting the well-drafted complaint. I mean, really what we're looking for is not that the department, assuming they get properly served, the Department of Education will show up. They're not going to default, but the idea is you're drafting the complaint such that if the defendant did default, the court would still be in a position to give you your default judgment. And service of the summons and the complaint. So this is what I see the pro se litigants have a lot of trouble with. I mean, obviously the attorneys are going to know how to figure this out. So if you are going to name the Department of Education as a defendant, you've got to serve the United States Attorney for the Northern District of Georgia, the Attorney General for the United States, the U.S. Department of Education, and then of course any other named defendants that you have if you've got additional loans that you're trying to serve. So in order to, and obviously, I mean, you're going to have to do that if you're going to litigate the case, but even if you're going to go through this attestation process, the guidance provides that the complaint has to be filed and properly served. And so that is where, I mean, there are some debtors who could get through the attestation process pro se, and there are some debtors who have gotten through the process pro se, but sometimes it's getting them over the hump of serving the complaint that is the hardest part. And then once they do that, they can fill out the paperwork. But yeah, you have to make sure you get it served correctly.
And so tip 6, once you effectuate proper service, please contact my office. It is really helpful when plaintiff's counsel emails me with a copy of the filed complaint along with written confirmation that the debtor is in fact interested in this attestation process. As you will hear later, the attestation process is not required. You certainly can proceed with litigation. And so it's helpful at the outset to understand if the attestation process is something that your client wants to pursue so that we can begin positioning everything in that regard. Once we receive the attestation, once we receive the complaint and notice of your action, we'll begin to apply the guidance to the adversary proceeding. Now, the guidance has two components. First, it articulates a legal framework for assessing undue hardship. And second, it creates a process whereby debtors would prepare a specific form, which is called the attestation, and debtors would present that attestation form to my office to facilitate the undue hardship assessment. Now, it's important to note, as Judge Sigler indicated earlier, the guidance does not alter the controlling legal authority in any fashion. Instead, it works within the framework of existing authority to present a path towards student loan discharge for federal student loans through discussions with the government. And so under the guidance, it does track the 3 prongs of Bruner as earlier articulated. See if I can get the slide to the right location. There we go. So the guidance encourages those attorneys representing the United States to employ IRS standards in order to determine whether or not a debtor can make loan payments while maintaining a minimal standard of living. For prong 2 of Bruner, the guidance establishes a certain number of factual circumstances that give rise to a presumption that the inability of the debtor to repay the student loans would persist for a significant portion of the repayment period. And those presumptions include where the debtor is age 65 or older, where the debtor failed to obtain the degree for which the student loan was procured, and where the debtor has a disability or injury that impacts his or her income and earning potential. Now, I do want to note that for purposes of the disability or injury presumption, we do not have to have proof of total and permanent disability. In the past, you may be familiar with the total disability discharge process, and that required a very onerous set of materials elicited from the debtor's medical professionals. That is not required under the presumptions throughout this guidance. Please note that the presumptions are rebuttable, and if we have concrete evidence that the debtor would in fact have the future ability to repay, then the standard would not be met for prong 2 of Bruner.
I'll also note quickly on prong 1, I don't know what the Department of Education's position is on this in the attestation context, but in the Savage case, the debtor lived in a home that was owned by his sister and had for, a decade or more, and sometimes he paid rent, sometimes he didn't pay rent. But there's other case law out there which I followed, which basically said that, the sort of generosity of family and friends in providing a debtor a place to live it does not then become an obligation on that third party. So even though he had a good living situation that he didn't pay a lot for, or sometimes didn't pay for at all, he could still have used the IRS, amounts for rent in the calculation. So even if your debtor is paying $0 in rent because of one of those situations, you could potentially still argue that you should be able to take that IRS rent deduction.
Absolutely. The guidance specifically provides room for those reasonable expenses that are not currently being incurred, but that should be assessed and included in a review of the debtor's entire financial circumstances. So if there is a need to replace a vehicle, or there is a upcoming housing expense that can be anticipated, those are factors that can be included in the assessment under the guidance. And so then enter the guidance as to the third prong. The guidance indicates that good faith may be determined in many ways, including making payments, applying for deferments or forbearances, or engaging meaningfully with education or one of the servicers regarding meaningful student loan repayment options. Now, I do think it's important to note that a debtor's failure to make payments or failure to enroll in an income-driven repayment plan are not dispositive under this third prong. As indicated on the slide, the point is really to assess the debtor's behavior and payment history within the broader context of the debtor's financial circumstances and their financial means. I think it's also important to note that the guidance has been really explicit in acknowledging that some debtors have historically been deterred from seeking a discharge of student loans in bankruptcy, specifically because of the historically low probability of success and the cost and intrusiveness of the discovery process and the litigation that is necessary in pursuing an adversary proceeding. So this guidance is intended to redress those concerns so that where a discharge is appropriate, it may be sought and received. Now, again, this attestation process under the guidance is intended to serve as an alternative to the traditional student loan litigation process. And so much of the work that is done in these cases is behind the scenes, and the docket may not reflect all of the activity that's happening in a case.
So as we kind of touched on earlier in the context of, do you file just against the Department of Education or do you join in your other defendants? In any of these situations, you may need to seek a stay of litigation. So you file the complaint, you contact Ms. Jones' office and let her know that you're interested in proceeding with the attestation process. And so then you can seek a stay of litigation and adversary proceeding so that you're not required to go forward with discovery, and all of those deadlines under the local rules are not passing you by.
And so often, and I believe Lauren can speak to this, if there's a adversary that's filed that may contact, we may immediately put in place the documents to stay the litigation so that we can collect the necessary information from education, provided allow the attestation process to move forward without the additional overlay costs and burdens attendant to litigation.
Absolutely.
And so once you file and serve the complaint and contact me to express the interest in the process, as indicated, education begins the process of collecting some helpful information to provide to you and your client in order to complete the attestation form. Some of the information that education may present may include the educational history, the transaction history or payment history, related information, sometimes the actual signed loan documents. Education will collect all of this data, they provide it to me, and I will produce it to you so that you and your client can complete the attestation form. And this form really requests information about the debtor's income, the debtor's expenses, their household size, whatever anticipated future medical or financial circumstances may exist, and additional information just necessary to allow for the assessment of the debtor's circumstances consistent with Bruner. And I will note that because this attestation is designed to facilitate our discussions and will contain some particularly sensitive information, especially when we're talking about some of the younger family members or medical conditions, it is imperative that you avoid filing the attestation on the docket. Please provide that attestation and any related supporting documents to my office. And once you present the attestation form to me, my office, along with Department of Justice and Department of Education, will review it and determine if there is some additional information that we may need. Lauren, anything else on preparing the attestation?
Probably by the time you actually, and I do wait, you could submit the attestation, I think, right after you file the student loan adversary, but I prefer to wait for that packet from the Department of Education. It does have a lot of helpful information in it, and they often have this very beautiful summary at the beginning where they say what elements of the process they think that your client has met. So I have been waiting for that to come back and then filling the attestation out with the client. But other than typically, getting updated pay stubs, reviewing with them to make sure, nothing has changed, or to, if something has changed, to just make those updates. A lot of the work that you will you will have done most of the work needed to actually fill out the attestation long before you actually get it back.
You have a well-drafted complaint, and you've already got the information that you need.
Yes, absolutely. One thing I want to note is that a parent plus loan is always going to fit the future prong. One of the questions is, did you or did you not obtain the degree that is the basis for the loan? And so if you have a parent, if you're filing for the person who has the parent plus loan, they did not get the degree. So that's just one of the tips about that specific aspect. For the pass prong, a good faith effort to repay the debts. I was, concerned when I first started doing the first few attestations that this, could potentially be, depending on how it was interpreted by the Departments of Education and Justice, a potentially a difficult standard to meet. But that does not seem to be the case. I've had clients who have both enrolled in income-driven repayment and clients who have not. So I have not found that they, just like the Departments of Education and Justice said, I don't think that is something that is taken as evidence of bad faith. But I have had everyone who has received the discharge has had some reason for, potentially not engaging with the income-driven repayment plan, or they had, started the process, but it had been years and they never heard back. And I do think, I think Navient is in the process of settling for maybe 120 million. And I think one of the things that has come out is that they've misled borrowers about the income-driven repayment plan. So I do think that there is an understanding on the part of the Department of Education that simply not enrolling is not evidence of bad faith.
But it's helpful to get that information from you and your client's experience and the rationale for the actions that your client has taken or has declined to take. If you're able to present all of that information, particularly in the attestation form, that's really helpful. All right, so again, once you produce the attestation, if we do need some additional supporting documents, I will reach out to you and make that request. What you see on the screen is not a standard set of supporting documents that are requested in every case. Rather, the information that you need to present depends on the specific facts and circumstances of your client's undue hardship claim. So whatever forms the basis of the undue hardship claim should be presented within the attestation and the supporting documents in order to satisfy the burden under Bruner. I will say that one of the things that has been helpful is that some experienced counsel will attach to the attestation form a 2 or 3 paragraph narrative that goes into some depth and explains whatever circumstances are afoot. They often also attach the income and expense calculations, similar to the ones that Lauren indicated that she was preparing and generating in the initial conversations with her client. And then folks will also append all of the core or key documents that support the undue hardship claim. And when those documents are all presented in a coherent and organized fashion, that really does help speed up the process. Anything else on supporting documents?
Yeah, so you're definitely going to want to include things like pay stubs or the tax return, whatever you're wanting to use as evidence of the monthly expenses, along with like benefit letters, something like Social Security statement or food stamp statement showing whatever else that they are bringing in each month. And then you're going to want to include, evidence of chronic or serious medical condition. If you're arguing that prong, you're going to be asked for it. So you might as well include it in the initial documents that you submit along with the attestation. It has been pretty limited. One of the concerns I had when I started the process was also, are you going to kind of get into a doom loop of document production, with your client, where the documents they produce, necessitate more documents and more questions. And that really hasn't been my experience. Some of the attestations I've submitted didn't require or did not yield any requests for additional documents. Some of them, they requested something like a Social Security earnings statement, not the monthly statement, but the year-over-year income or a tax return, things that I've been asked to provide, but that are less likely than the other documents are things like maybe updated pay stubs if a certain amount of time has gone by, proof of a particular expense, or even something like resume or jobs applied to. But I would not start out by producing all of those documents. I would limit it as much as possible to what you feel you need to submit to support what you're laying out in the attestation, and then wait for an additional document request before providing much else.
Yeah, I think that's fair. All right, and so while we're in that process, it's important to keep the court informed.
And that really can be, I mean, as long as it's stayed, I mean, this is a know your judge, right? So probably in my courtroom, as long as it's stayed, I'm not really going to worry about it. There could be some judges who want to have a periodic status conference. You might be able to get around that by saying, well, Your Honor, what if we agree to file periodic, status reports? But that's all we really need. Just once that stay expires, we are assuming that discovery is proceeding. So just make sure that you either have the stay in place or the court knows what's going on and you get that stay back in place if you're not done with your process.
And I have found that if there is a time where the entire process becomes stalled, that it is helpful to set a status conference with the court just to reset everyone's understanding about how we're moving forward. And so that is something that could be possible.
Yes, and certainly that has been necessary and helpful in some of the pro se cases that I've had.
So the next tip is to consider some alternate resolutions. And again, I would remind you that, again, the guidance process is not required, and it can be used at any point during the litigation. So if for some reason your client is not interested in the attestation process, we can certainly proceed to discuss and present an appropriate scheduling order and move forward with litigation. I will also note that some of the administrative discharge options that have historically been available remain available and do not have to become part of the attestation process. So for instance, public service loan forgiveness, that is something that continues to operate. It is an administrative discharge option that is available to the appropriate debtors. To the extent that you're interested in some of those other options, I would encourage that you consult the resources at studentaid.gov. Anything else?
Yep, that's one of the things you're gonna ideally look at ahead of filing is something like the public student loan forgiveness, so that you don't have them go through the attestation process if they're close to qualifying for a different, probably less expensive. Same with some of the administrative discharge. We've directed clients to the total and permanent disability discharge based on their circumstance. I have not filled out those forms with the client, but we have directed them to those forms. My understanding is that typically they might be able to expect an answer within maybe 60 days or so. Is that?
I mean, I think it varies, but you're welcome to explore that option.
Yes, absolutely.
All right, and so to the extent, however, that we do proceed through the attestation process, and education and the Department of Justice review the attestation, the supporting documents, and determine that they can agree to the relief that the debtor is seeking, then you will coordinate with my office. I will contact you to let you know of the decision by the government, and we'll work together to present stipulations and a proposed consent judgment to the court, providing for the partial or full discharge of the student loans as appropriate.
And I will sign it.
All right, that's everything that we have for you today. Are there any questions that we might address?
All right, well, it doesn't look like we got any questions in the chat. But thank you all for joining us.
Thank you for joining us and giving all of this wonderful information to us. Again, all the information from today will be on the website. So check back there and look for all of our past programs as well. Thanks so much.
Thank you.
Thank you.